to invite Robert Stewart, Executive Officer, Kansas Bureau of Investigation. Please introduce yourself and welcome to committee.
Thank you. Madam Chair, members of the committee, my name is Bob Stewart. I'm the Executive Officer for the Kansas Bureau of Investigation. I've also brought along with me KBI Assistant Special Agent in Charge, Corey Nation, who oversees, amongst many other responsibilities, oversees our clandestine lab investigations and methamphetamine investigations. He will be available to answer questions that reach technical levels beyond my capability to answer. Thank you for the opportunity to talk to you today about the methamphetamine recommendation report that KBI provides annually. This year we provided it to you amongst other committees here at the building on January 10th of this year. I don't want to read through it. You have it in front of you, I know. But I do want to talk both about it a little bit, but also kind of work backwards or start kind of at a previous level because I understand and expect that all of us have heard the term methamphetamine, but we don't particularly understand where it came from, what its impact is, where we see that going, and how we feel like from a law enforcement perspective we need to deal with it. So with your forbearance, I'd like to sort of work through it that way. As you know, the report that's in front of you is required by KSA 75-722. That was a law that was established in 2005. That was, at the time, methamphetamine was then and still is today the biggest drug problem in the state of Kansas. But then the issue was it was being homemade. It was being made in what we call clandestine labs in rural places particularly, but sometimes not rural places, across the state. It was dangerous not only to the producers, it was dangerous to the community, it was environmentally dangerous, there were lots of issues. So upon advice from law enforcement, this body took it upon itself to establish laws to make it more difficult to make methamphetamine in Kansas by limiting precursor accessibility and some other things that you did. Part of that was this report is required every year. So thank you for both that law at the time and thank you for your continued consideration and understanding that this is a continuing issue. Amphetamines are, as a big chemical class, are a central nervous system stimulant. They come from the ephedra plant, which is native to China and to Mongolia. It's been used for centuries in that sort of stimulant world to deal with asthma and lots of other things as a sort of a home remedy for decades, for centuries. In the 1800s, scientists identified the chemistry inside the ephedra plant that we call amphetamines now, that are what stimulate our bodies, and it stimulates the dopamine system. And since that time, they've developed a number of drugs that are both positive in nature, but also very dangerous in nature since that time. Two of the ones that, they're all synthetically produced now. Two of the ones that you're probably most familiar with from a pharmaceutical perspective are Adderall and Ritalin. They're both in the class of amphetamines. Of course, methamphetamine is also in the class of amphetamines. Methamphetamine was first produced in the 1980s. The problem with it is a Schedule II regulated federal drug. It has only one prescription application, and it's very, very rarely used, as I understand it. It is highly addictive. We believe that more than 25% of abusers or users suffer from psychosis and severe mental disorder when they abuse methamphetamine, and there are a host of other physical and mental consequences. It kills slow. You've heard me and the director testify, and one of the things that you've heard us say in the last couple of years is the fentanyl problem. Fentanyl, we know one pill can kill. It kills very fast. Methamphetamine kills slow. You've seen the ads on TV, the pictures of somebody, there's 3 or 4 pictures. They start off as a 20-year-old man that looks pretty normal, and then a picture where he's been booked into prison at 22, and he looks 10 years older. And then a picture at 24, and he looks 3 years older than that. And then the next picture, he's dead. It takes years, but methanol does kill. Or pardon me, methamphetamine does kill. We do know still today that 49% of drug overdose deaths come from psychostimulants. Meth, Adderall, and Ritalin are included in that psychostimulant category. So while we've talked about, and you are very familiar with the fentanyl crisis and the number of people dying from fentanyl, it's still very important for us to not take our eye off the ball of how dangerous these amphetamines are, in particular methamphetamine. pardon me. The high-intensity drug trafficking region that we're part of is the Midwest, and they're located in Kansas City. It covers the entire Midwest states. They rank a lot of different categories, and one of the things they rank is the drug threats. And they don't do that based upon their own opinion. They gather survey data from all law enforcement for us in the state of Iowa, Kansas, Nebraska, and part of Illinois, I think, and Missouri. They rank methamphetamine abuse as the second most dangerous drug issue in the Midwest. The first is fentanyl. And as I mentioned, we're ranking fentanyl first because it has come up so startlingly in the last several years and because the death is so sudden. One pill can kill, and we've talked, and you know about situations where a kid has gotten one pill that's the wrong pill and end up dead. That's why we rank fentanyl first. But methamphetamine in the state of Kansas and in the Midwest is still the illegal drug of choice. It is still the main contributor to both violent and property crime, according to all the law enforcement partners that respond to this survey to HIDA. It is still very easy to get. The survey of all those law enforcement agencies say that about 91% of those respondents say that meth is highly available in their area of responsibility. It's more available in some places than marijuana as an illegal drug. It's more available than fentanyl. It's easy to get, and it's right now very inexpensive. We have been very effective with your help at dealing with clandestine labs. If you look at the report, you can see that the number of clandestine lab investigations has steadily gone down. Last year, there were 4 clandestine labs that law enforcement in the state of Kansas dealt with. There's several reasons for that. Some of them are economic, but the big one is the Mexican cartels have taken control of the manufacture of methamphetamines and do so in Mexico. They're what we call super labs. They make very, very, very high quality, very potent methamphetamines. The American labs, the DEA lab, has read it out as some of the samples that they've gotten are 97% pure. That's pharmaceutical level purity that the Mexican labs are making and sending across into America. That purity, it's also inexpensive for them to make, so it was a pure product and a cheap product for methamphetamine abusers to use in the state of Kansas. They transport it across the border in a couple different ways. They can transport it in ice form or in crystal meth form, which is the kind, it looks like little crystals. It can be transported that way. One of the newer ways they do it, they had some chemists that were smart enough to figure out how to take methamphetamine and put it into solution inside another liquid. One of the ways they do that is they can take methamphetamine and dissolve it into gasoline or other automotive liquids and then bring it across the border. It's very difficult to detect bringing it across the Mexican border in that format. So they drive it across the border in what would otherwise be gasoline containers or other, they found like windshield wiper containers that inside the car, instead of windshield wiper fluid, they're filled with a liquid that's gotten methamphetamine dissolved into it. Then when they get it across the border, they go into a conversion lab and basically dry it out and dry out the methamphetamine back out of that liquid and then sell it. So it's relatively simple, or has been lately, relatively simple to get across the border by way of this chemical conversion into a substrate inside a liquid. I mentioned the production and how easy that was, but also the cost has been going down. In 2024, we estimate the cost at about $360 an ounce. In 2022, it was about $500 an ounce, so it's gone down in that. And in 2014, it was about $1,000 an ounce. So we've always talked about the economics of the drug war, the economics of the drug trade. The economics have gotten to the point that it's a cheaper drug at better purity for the people who abuse it in the state of Kansas to get. So it's certainly still important. We would back up those HIDA numbers with Kansas Bureau of Investigation lab numbers. And I will give you the 2 areas. We have 2 units that's in our lab that sort of would have touched this. Our chemistry unit and our toxicology unit. The chemistry unit is the one that any law enforcement in the state of Kansas would bring in a sample. They've done an arrest and they've got something they think are drugs. We would then analyze that to determine what drugs, if any, are in there. In fiscal year 2024, the lab did 13,289 of those chemical analytic tests. 38% of them, so 4,756, tested positive for meth. By comparison, 8%, or 1,047, tested positive for fentanyl. The others, to round that out, there probably 40% is positive for marijuana, and of course we get 6 or 7% that don't test positive for anything. There's some heroines and some others in there as well. But traditionally and typically for the last 10 years, 35 to 40% of those tests that we do in our chemical labs test positive for methamphetamines. That's a very pretty steady number that comes through there over the years. So the problem hadn't gotten any bigger, but it hadn't gotten any better either. Our toxicology lab would sort of confirm those numbers. Toxicology is the blood sampling. So somebody has taken a blood sample from a DUI case or a roadside stop or somewhere else where we've gotten a blood sample in a case. The FBI lab, or the KBI lab, I'm sorry, has tested in 2024 1,802 samples. Again, 38%, or 635, tested positive for meth. By comparison, 206 or 12% tested positive for fentanyl. So the fentanyl numbers 3 or 4 years ago were 1 or 2%, and they've gone up to 12% that we found in the blood samples that law enforcement has submitted to us. But that same methamphetamine number, just like in chemistry, has stayed very traditionally the same, about 35 to 40% every year, year in, year out, of those tests that we get are testing positive for meth. So it continues to remain a significant problem in the state of Kansas that we cannot take our eye off of. Now we want to talk, I want to kind of close on where we are with some trends and what we think is going to be happening. Of course, as you can see, this report was dated January 10th. January 20th, something happened that we're all aware of. And what has happened very quickly out of the change in federal administration is the border has gotten very tight very quick. And we expect that that will continue. What does that mean in terms of the methamphetamine problem? We suspect, law enforcement in the state of Kansas, the KBI suspects, that that is going to tighten the supply from Mexico to America. That's a good thing. However, our drug abusers and the drug producers that are in Kansas are going to find other ways to economically provide their customers, which means that we expect our clandestine lab problem to, instead of over the years getting smaller and smaller and smaller, we expect that it's going to get bigger and bigger and bigger. We expect the price is going to go back up, and we expect that there's going to be pressure economically for people to start making clandestine lab methamphetamine in the state of Kansas again at a higher rate. It's a simple economic problem. And there's another piece that we're starting to observe, and that is, as we've testified to you before, fentanyl is starting to be laced into all kinds of other illegal and otherwise potentially legal drugs. It adds to the high. They're trying to get you hooked on fentanyl. There are a lot of reasons why they're doing that. Sometimes we're finding that the users of methamphetamines are scared about the fentanyl. So they are trying to find ways to have pure meth without the fentanyl, thinking that maybe if we manufacture it ourselves or have a local manufacturer, we won't have to worry about fentanyl being laced into our meth. It doesn't sound like a problem I'm personally worried about, but I think if you're a meth addict, you are worried about that at some level. That will increase, we believe, the pressure to locally produce methamphetamine again. So with that, I think our conclusion is we expect it's going to get more expensive. We expect we're going to have more meth labs, and we can't take our eye off of that ball. And with that, I'll stand for questions, and what I can't answer, I'll certainly have Corey answer.
Thank you for the very thorough presentation and for the report. Appreciate it. Committee, do we have any questions? Yes, Senator Reichman.
Thank you, Madam Chair, and thank you very much. I forgot your name for your presentation. It's been a long time since I've been on Judiciary, and it's very thorough presentation. But when you talk about the price of it going down and like $3.60 an ounce, how many hits or high can they get off an ounce, or what do we talk about here?
Well, let me have Corey come in and answer that question for us.
Please introduce yourself and welcome to committee.
Hi, my name's Corey Nation. I'm an assistant special agent in charge with the Kansas Bureau of Investigation. Normally with methamphetamine, with your question, sir, the user amount is normally about a quarter of a gram or less. So there can be multiple uses in an ounce of methamphetamine.
Thank you. Senator Corson.
Thank you, Madam Chair. It was a really great and thorough presentation. I don't believe you had any recommendations for us as a legislature to help address this challenge. Is there anything that you would recommend that we take a look at that we could do to try to help be a good partner in helping you fight this, what I think is, as you've stated, a really serious challenge for us, and we want to be a good partner in that effort? And if you have ideas for what that could be, or if you need anything from us, we'd just be curious. Thank you so much.
Thank you, Senator. At this point, I think from a legislative perspective, we have the laws in place that we need. It's just the continued observance of it. And certainly you're all aware of what and have been very gracious with your funding regarding our fentanyl task force. That sort of spins off into this as well. We don't particularly have an ask today in any of those regards, other than your continued eye on the ball with us as we're watching it. And next year it may get worse, so we may have different responses next year.
Well, we don't always often have people come before us without an ask, so that's kind of nice. So we appreciate it. Thank you.
You know our ask this year is for a new building, so.
I do think we have some bills that have been introduced regarding higher penalties for deaths related to fentanyl if you're involved with that. So I think we are looking at the penalty side of prosecuting fentanyl deaths and crime. So those I think are being processed as we speak. So we should probably be hearing on some of those later this session. So with that, do we have any other questions? Not seeing any, then thank you very much, Mr. Stewart, for your presentation, and yours as well. Appreciate you. Next, we're going to open the hearing on Senate Bill 135, providing precedence of child-related orders issued under the Protection from Abuse Act. And with that, a bill brief from the reviser. Ms. Scott, thank you.
Thank you, Madam Chair. Senate Bill 135 amends KSA 60-3107. That's the procedure statute that's in the Protection from Abuse Act. Current law there provides that orders can't be modified on ex parte application or on motion of temporary orders and other specified actions, and orders previously issued in other specified actions are subject to modification for good cause and immediate and present danger of abuse to the plaintiff or minor children. That would be what constitutes good cause under that section. This bill retains that prohibition on modifying the order by a subsequent ex parte or temporary order, and then it clarifies that an order relating to legal custody or parenting time, an order relating to the best interest of the child, or an order issued under the revised Kansas Code for the Care of Children or the revised Kansas Juvenile Justice Code shall take precedence over a similar order that's issued under the Protection from Abuse Act. It also provides on a sworn statement showing good cause. The Protection from Abuse Act orders may be modified, may modify an order related to legal custody, residency, and parenting time that's previously issued for either the determination of parentage or divorce, separate maintenance, or annulment. And on a sworn statement showing good cause orders under the Protection from Abuse Act, they can modify interlocutory orders issued under 232707. And then the bill also retains that provision that immediate and present danger of abuse to a plaintiff or a minor child constitutes good cause. And I can take any questions.
Thank you. Committee, any questions? Well, thank you very much, Ms. Scott. Appreciate it. Committee, we're going to invite proponent conferee Ronald Nelson from the Kansas Judicial Council for testimony. And please introduce yourself and welcome to committee.
Thank you very much, Chair. Committee, I am Ron Nelson, Ronald W. Nelson. I'm on the Family Law Advisory Committee to the Kansas Judicial Council. I am a family lawyer with my practice in Shawnee Mission, but I practice across the state, and I've been practicing family law for a long time now, I guess 40 years. This bill in front of you essentially makes no substantive change to the Protection from Abuse Act statute, the procedural statute, with one exception. In 2021 and 2022, the Family Law Advisory Committee undertook a review of the protection from abuse statutes, the protection from stalking statutes, to try to decide if there was any way that we could consolidate those statutes, make them more understandable, make them more streamlined, and make the process better. In doing so, it was determined that the protection from stalking and protection from abuse acts should stay separate. But it was discovered that one of the big problems in the protection from abuse statute is 3107, which this bill changes. The problem with the statute is that it's very, very confusing. That confusion was made worse with the legislative changes in consolidating all of the family law statutes from a variety of places, including Chapter 38, Chapter 60, into Chapter 23 with a new family law code. So in the old statute, in the markouts, you will see a reference to KSA 2327 or 3701, 02, 03, formerly known as or formerly referenced as KSA 60-16, whatever. This modification, these amendments of this particular statute really are focused again on simplifying, making more understandable, and taking out a lot of the statutory references in the existing statute that really are no longer necessary or no longer needed, just cause more confusion and complication and lack of understanding by courts, by attorneys, by self-represented parties, and by the public. So this statute is not a substantive change, is not intended to be a substantive change. There is one exception to that, as I indicated, and that one exception is that the language includes that the PFA temporary orders, the PFA final orders, can change and modify any action or any child custody, residency, and parenting time orders in any kind of action. So that includes divorce cases, including separate maintenance, parentage cases, and, excuse me, but also, and the substantive changes, including guardianship orders. The importance of that is that guardianship orders were previously excluded because they weren't specifically referenced. And the problem there is that there's elder abuse, there's various other kinds of abuse of disabled persons and others who have guardianship that really need this kind of special protection in a protection from abuse rather than having to go through the probate procedure and the guardianship procedure. And that is basically it. I will stand for questions.
Thank you, Mr. Nelson. Appreciate your testimony. Committee, any questions? Yes, Senator Bowsers.
Thank you, Madam Chair, and thank you, Mr. Nelson, for your testimony this morning. Just for my education, would neglect be considered abuse?
The protection from abuse statute specifically defines what is included as abuse, and that is intentional physical harm or threats of physical harm. Neglect is not unless it really falls over into that. Neglect with regard to a child at least falls over into the child in need of care proceedings and statutes. Elder neglect falls over into that area.
Okay, good, thank you.
Thank you. I have a quick question. With the bill, so prior proceedings, a divorce, a parentage action, a separate maintenance action, guardianship, primarily divorce with minor children. So child support has been determined in the divorce proceedings, and then there's a protection from abuse temporary order and later a final order. So the PFA temporary order, in that hearing on the PFA, the judge, different courtroom, different jurisdiction, possibly different county in Kansas, could modify the child support order. Is that correct?
It is correct. It is rarely, if ever, done.
Well, and we know that because
Just experience.
currently a PFA temporary order could change child support, and we don't see that happen?
That's correct.
Okay, so currently a PFA temporary order could do that, and it's not used in that manner. So, because you said this is a procedural change, not a substantive change.
Right. And specifically with regard to that, the emergency orders that are issued and protection from abuse orders really are specifically addressed to protecting the filing party from the abuse, not from the consequences of whatever change there may be. In a number of counties, what the judges will do at a final PFA trial, or if it goes on longer than 21 days, will call both the family law case and the protection from abuse case at the same time, so that the same kind of testimony will be heard in that matter. As you indicated, there is not, well, a protection from abuse case need not be filed in the same county or district as any existing family law matter. And in fact, if there is a divorce pending in another state, a PFA can be filed in Kansas that may modify that out-of-state order to some extent, but then you get into interstate recognition and other kinds of issues.
On the notice that's provided on the PFA hearing, does the notice include that other actions such as the divorce proceeding, the parentage, separate maintenance, guardianships might be heard in that PFA hearing as well?
No.
So how would one appearing for a PFA hearing know that their divorce proceedings might be impacted at the PFA hearing?
The standard order that is issued includes information and instructions on what is affected by the order, if any orders are actually issued by the judge.
So it's standard on the notice, not particular to a particular person who's being, who's a party to the PFA.
Yes. One of the things that Family Law Advisory Committee does is frequently, constantly reviewing and revising the forms that apply to family law matters and protection orders, including stalking and abuse. So that's one of the main things that Family Law Advisory Committee has done for 15 years. And so we get into the detail of all the kinds of notifications, and there are different kinds of forms that we have. There is a notice form that simply notifies when the hearing is scheduled and whether or not an order has been issued, and the time within which to file a response or to appear. And then attached to that, excuse me, is the petition itself, as well as the Uniform Child Custody Jurisdiction Act affidavit, and other things that are filed at the same time to give full notice, not just a notice of a hearing.
Thank you. Committee, other questions? Not seeing any, then thank you, Mr. Nelson, for your testimony. We will next hear from Michelle McCormick, Executive Director, Kansas Coalition Against Sexual and Domestic Violence. Please introduce yourself and welcome to committee.
Sorry. Good morning, members of the committee. Michelle McCormick. I am the Executive Director of the Kansas Coalition Against Sexual and Domestic Violence. Thank you for the opportunity to be before you today, and also thank you for calling Mr. Nelson first, because I'll remind you, I am not an attorney. I'm a social worker and lead the organization. We're a nonprofit organization that is the membership association for the 25 programs across the state that provide direct services to victims and survivors of domestic and sexual violence. We also collaborate to work on public policy initiatives with our partners across the state in order to center the needs of victims and survivors. And we work with the Judicial Council's Family Law Advisory Committee. And so really, in 2022, what our organization brought to the Family Law Advisory Committee was the need. We get a lot of questions from attorneys who represent victims and survivors, from our victim advocates who we support, and from survivors directly about this particular statute and the lack of clarity. And so really, you have my written remarks in front of you, but we want to offer our organization support for these changes. In particular, in our experience, the more clarity there is about these statutes, the better it is for victims and survivors to be represented better, and also just to have the knowledge that they need in order to know what the legal structures, how that can impact them and their children's lives. And so we're here in support, and I'd be happy to answer any of your questions. I did, if I could, Senator, I wanted to, I think Mr. Nelson addressed it, but I just know from supporting victims and survivors through these processes for many, many years that the respondent does get that copy of the petition, which has all of the changes in the temporary order as well, that has all of the changes that a judge may have made during that process. And so they get the full copy of that petition, which I know it's not maybe the same as the notice, but having the copy of the petition, I think, gives them that information if a judge makes a change. So I'd happy to answer any other questions.
Thank you. Thank you. Committee questions? Not seeing any, then thank you for your testimony today. Appreciate that. Are there any other persons in the committee meeting room or on WebEx wishing to testify as a proponent, a neutral, or an opponent? Not seeing any, then thank you for the testimony today and appearing here in committee, and we will close the hearing on Senate Bill 135. Committee, we do have some opportunity for possible final action on bills previously heard, so we're going to pull up a couple of those. And one of those should be familiar to you. It's Senate Bill 71. It's regarding increased penalties for buying sex relations, and we'll ask for a brief bill brief from the reviser. Senate Bill 71.
Thank you, Madam Chair. Senate Bill 71 increases the criminal penalty for buying sexual relations. It also removes provisions regarding city ordinances prohibiting buying sexual relations, and it requires certain offenders to complete an educational or treatment program regarding sexual exploitation that's approved by the Attorney General, and then it requires the Attorney General to approve that program to be used under those sections in consultation with the Office of Judicial Administration.
Thank you, committee. Any questions for the reviser? Any discussion on the bill? And I will entertain a motion on the bill. So, yes, Senator Titus.
Thank you, Madam Chair. I would move the committee recommend Senate Bill 71 favorably for passage.
Thank you. Is there a second? Senator Klemp? You all have heard the motion. Is there any discussion? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. And that will be then our first bill worked and passed out of committee and sent to the Senate floor. So it's a priority, I know, for many across the state, and want to thank Prosecutor Kage, who's here this morning, District Attorney Kage. So thank you for your work on the bill and for all those who helped advocate. So appreciate your work on that. Next, I'd like us to take a look at Senate Bill 30 regarding criminal background checks and a bill brief from the reviser.
Thank you, Madam Chair. Senate Bill 30 requires the Secretary of Labor to conduct a state and national criminal history record check on employees who have access to federal tax information that's received directly from the IRS.
Thank you. Committee, any questions for the reviser? Yes, Senator Bowser, excuse me.
Thank you, Madam Chair. Just a comment, having worked at the Department of Revenue for several years, this piece of legislation seems very much in line with what other agencies do. I speak in favor of this bill. Thank you, Madam Chair.
Thank you. Committee, other questions or discussion? Senator Corson.
Thank you, Madam Chair. I had during the committee hearing, I had asked a question about juvenile records and access to those records and how that would be handled. I just wanted to share with the committee that I'd since received information about that one of the challenges with trying to exempt or trying to remove from the bill juvenile records would be that this is a nationwide search, and so you'd have to be familiar with all of the financial crimes as they're defined in all of the different states. And so I did inquire about it at the hearing, but based off feedback I got, I'm comfortable with the bill as written, and I think it makes sense, and I do think it might be a little bit unwieldier than I had initially thought were we to try to carve out exceptions for different juvenile criminal activity, because we'd have to put the onus on the KBI or the person conducting the background check of figuring out how those are all defined under state law. So with that said, I'm comfortable with the bill as it is. I was glad I inquired and wanted to just share that information with all the other members of the committee. So thank you, Chair, and thank you, Vice Chair.
Are there any further comments on Senate Bill 30? Seeing none, is there a motion? Senator Bowser?
Thank you, Mr. Vice Chair. I recommend we favorably pass this bill.
Seconded by Senator Argabright. Any further discussion? Seeing none, all those in favor say aye. Aye. All opposed? Bill is recommended favorably for passage. Let's turn next to Senate Bill 53, if we could get a summary from the reviser.
Thank you, Mr. Vice Chair. Senate Bill 53 provides that the attorney members of the Board of Trustees of a county law library in certain counties shall be appointed by the Chief Judge of the Judicial District, and it allows the board to authorize the Chief Judge to use certain fees for the purpose of facilitating and enhancing functions in the district court of the county.
Are there any questions on Senate Bill 53 for the reviser? Seeing none, any questions or comments in general on the bill? Very well. What would be the will of the committee on Senate Bill 53? Senator Corson?
Thank you, Mr. Vice Chair. I would move that the Senate Judiciary Committee pass Senate Bill 53, recommend it favorably for passage.
Very good. Is there a second? Senator Rose? All right, it's been moved and seconded that we pass Senate Bill 53 favorably for passage. Any further discussion? Seeing none, all those in favor say aye. Aye. All opposed? The bill is recommended for passage. Thank you.
Thank you, committee. Next, I'd like to bring up for final action Senate Bill 84. 84, we just heard yesterday regarding gift card theft. So with that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 84 modifies the crime of criminal use of a financial card to include certain conduct involving gift cards.
Thank you. Any questions? Any discussion or a motion? Senator Titus.
Thank you, Madam Chair. I would recommend, the committee recommend passage of Senate Bill
84.
84 favorably for passage.
Thank you. And a second from Senator Clays. Committee, any discussion? Then you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. Committee, appreciate your attention today and the work that does bring us up to date on bills that we have heard and would be eligible for final action that would be ready for today. So if you have amendments on others that we have heard, make sure you have those ready for when we work them. Please do look, we're going to have a busy week next week. We've had a lot of bills introduced yesterday, which was the last day for a request for bill introduction, and next week, and then Monday after our last opportunities to hear and work Senate bills. So please be prepared for a full schedule, and you should see that agenda out later this week. So we will be working Monday through Thursday next week, possibly Friday. So just check the calendar for that. And with that then, want to thank everyone for their attention and staff as well. And the meeting is adjourned.